It's time now to focus on law. In July this year, President Akufo-Addo signed into law a bill that officially introduced plea bargaining into the administration of criminal justice in the country in respect of all offences. But how will this transform the administration of justice? Or of what benefit will this be to us? So let's speak to the expert to help us understand this new law and its benefit to us. Rebecca Kwashi is a legal associate, Law and Development Institute, LADA Institute, and Cletus Alenga is also legal consultants for LADA Institute. Thank you, gentleman and lady, for joining us here. So ladies first, correct? So yeah, we need to practicalize this. So if we're saying plea bargaining, it's as though we're saying, okay, I've offended, I say yes, I have done so, but give me a limited time. Is that the correct notion to hold about this?
Not entirely. That's not entirely
okay, right.
The notion. The concept basically addresses the right to trial. And so constitutionally, every accused person has the right to be presumed innocent until that accused person has either pleaded guilty or has been proven guilty. So in the proof of guilt is done in a full trial. So plea bargaining is essentially saying that the accused person can opt to forfeit that right to full trial in exchange for a benefit from the prosecution. So in summary, that should be the concept. That is the concept. The accused person forfeits that right to a full trial in exchange for a benefit from...
Okay, so Cletus, what then happens if the person wants to forfeit that and just go through the plea bargaining process?
Yeah, so just taking that from where she landed. So you have the right to go through the full trial, which is what your constitutional right. But then if you now choose to enter into plea bargaining, now remember, you can actually plead guilty simpliciter without entering into plea bargaining. The law allows you to plead guilty to an offense. But when you do that, there is no, nobody is compelled to give you any benefit. So practically, sometimes judges take that into consideration in giving you a lesser sentence, but they are not bound to do so. Now, what the plea bargaining does is that you are able to actually arrange with the prosecutor and say, okay, I'm going to plead guilty to this offense. Let's say there's an option for a fine, there's an option for imprisonment, but I don't want to go to prison, so give me a fine. So, for example, if you jam a red light, you can actually go to jail, but the court can also fine you. So, if you are going to enter to plea bargain,
then you can
actually say that, okay, I don't want the jail option, but I want the fine option. Then you can actually negotiate that. And once it gets to court and then the court agrees, then you can plead guilty and then you take the fine.
It sounds simple, but then on the other hand, people have the view that we may be letting criminals off the hook, right?
Well, that is not entirely the case because in any event, at the end of a full trial, there's either going to be a conviction or an acquittal. Now, when if the accused person is convicted, the judge has the discretion based on the prescriptions for sentencing
to just go ahead,
pronounce sentence. But what plea bargain does is to shorten the process. It's not entirely letting the accused person off the hook, but it's to give both sides some benefit, facilitate the entire criminal trial, and then in the end, it's a win-win. So the state is able to secure conviction. The accused person is also able to get maybe a lesser sentence, which perhaps the judge might have even given him that lesser sentence anyway. And so it's just a matter of avoiding going to court for 3 years, 4 years, being on remand, and the population of remand prisoners going up yearly. I mean, all of these benefits are
and Cletus, for those who do not know about the direct impact on our judicial system, have we thought about that?
Yes, in fact, I will just to add to what he said before I answer your direct question. Rather than letting offenders off the hook, it's actually the opposite. Because once you are into plea bargaining, you are going to plead guilty. So you definitely...
So you have admitted even in the first place that you've committed the crime.
And then definitely punishment follows. What you can get most times is probably reduced sentence, or like I said, where there's an option for a fine or a jail, you can go. So you may get some benefit of it, but you are not letting anybody off the hook. That is totally out. Now back to your question. It's the judicial justice system, especially the criminal justice, is very constrained. there are a lot of backlogs in the court, and that's why people go to court and they get frustrated.
And they keep going
and
back
then you
and
get
forth. Right.
and a simple case like jumping a red light, for example, you can be in court for up to a year or 2 if you plead not guilty.
Whoa.
Because the police will have to call their witnesses. You have to call your witnesses, address to court, and back and forth and all those things. So just a simple case like jumping a red light, if you plead not guilty, you can actually go to court and then
you may end up spending more.
You spend more money. The court is constrained because there are other serious cases probably the court will need to deal with, but they also have to handle all these cases. The fact that it's small doesn't mean that they can jump the wheel of justice. So they have to still go through the same process. And so you have this chunk of cases piled up in court, which is causing delays in the court too. And it's also one of the reasons that we have a lot of remand prisoners, because the cases are not actually moving. Right. So people are on remand. They go to court
for a very long time.
And then they are there. Sometimes they might, even if they had been jailed, they probably would have been finished serving their sentence, but they are still there. So some of the benefits is to free up the case load in the courts, free up prisons, especially for remand prisoners, and not only even for remand prisoners, even for people who are convicted. Because if you are convicted, say, and then there's an option of a fine, and you get a fine, you release a prison rather than being put in jail for some minor offenses.
And then we know that this is a new law. So obviously the education, the awareness around it may be low. At LADA Institute, are you putting in place some measures, at least just to create more awareness on this?
Yes, so this is the first phase of the awareness creation. And like you said, the law just came in July. It was assented sometime in July. And so this is still like an early stage of the public education. But yes, there are plans to sustain this and then make sure that as time goes on, the education is intensified. There are plans of extending it into the prisons so that those persons on remand can also get to know of it. And if they opt or they want to take that advantage, they can also...
But as we speak, it's effective.
Yes.
So someone can just take advantage of it. It's not as though it's law anyway.
Yes, it is law.
Right. But do we have someone testing the law? Because I guess when the law comes out, it's practicalizing it or effecting it that we get to know how good or otherwise is it. Have we had that so far?
So like I said, the law just was assented in July. Right. And so, it's still early yet, but as the education goes, and I'm sure in a couple of months, we may hear accused persons wanting to take advantage of it. And I'm sure that as the prosecution also gets to implement these things, we'll start hearing of the practical aspects of it, the actual cases where parties have opted for plea negotiations.
Are there some reforms necessary at this point? Maybe the early stages of implementing the law, but revising it and going through it personally, do you feel that there are some things we need to improve on?
I believe it's early yet. So we would have to give the law some time to merge with the system. And that is when we will see where the shortfalls are, what things we need to build up on. Then we can take it from there.
Okay, Cletus, let's talk about even lawyers, right? The fact that the longer the case travels, the more you make money. So if you're going with a plea bargaining, that's going to come at some cost to the lawyers.
Not really. In fact, there are instances where you will finish spending the money and then the case will still be dragging for years on end. And I don't think the interest of every lawyer is to ensure that his client gets what he wants. And so if entering into plea bargaining is what will be beneficial to the client, you negotiate with the client, and then you also get your fees out of it. It's not as if because you were going to enter into plea bargaining. Because, mind you, even during the plea bargaining stage, you will need the assistance of a lawyer. Right. In fact, under the law, if the person if a child is involved, it's mandatory that they get a lawyer. And if you can't afford the services of a lawyer, you have to get a lawyer from legal aid to assist. Right. Yeah. So even going through the plea bargaining process itself, you will need legal assistance. Right. You will need to weigh your options. You will need a lawyer to advise you on your options, whether to even enter into it or not. And so it will not spoil any lawyer's business. Right.
But let's get into who can benefit out of this. Okay. Do we have a specific category that the law specifies as to who qualifies to benefit from this law? Yeah.
So I'm going to answer this in two phases. Okay. So the first is that accused persons, the prosecution and the state these are the parties that benefit.
Okay.
There are various benefits that inure to the parties. But then also, it isn't every accused person that can take advantage of this law. The law, when you look at Section 162R, it creates exemptions. So there are some category of offenses that if you're charged with, you are not entitled under this law to take advantage of plea bargain. So we have treason and high treason, high crime, abduction, piracy, hijacking.
So it's not a free-for-all thing.
No, it is not. Offenses relating to public elections, murder, attempted murder, rape, defilement. These are some of the offenses that if you're charged with, you cannot take advantage of. And you see that these offenses are grievous. Some are even capital. Right. So there's that exemption so that plea bargain does not apply to these. Yes.
So these are the exemptions. So how about individuals? So if for those who, you know, some people are already in jail, there are some people who have been convicted. Is there any hope for them in this? Maybe Cletus will take that. No,
once your case has traveled through, because the purpose of
lost the opportunity.
Yeah, the purpose of this one is actually to avoid going through the trial. And so if you have gone through trial and you've been convicted already, that is closed. That one, your option definitely will be to appeal or and see how it will work. But if you are on remand or your case has even traveled far, now the law actually gives that laxity. You can enter into plea bargain at any stage of the trial until final judgment is pronounced. And so until the judge has convicted you at any stage, you can. So even if you have done 90% of the full trial and you still feel that when you weigh your options, you still feel that entering into plea bargain will be beneficial to you, you can at that stage notify the Attorney General that you want to enter into plea bargain.
But then with someone who's seeking, for instance, a review, as you're pointing out, can they also take advantage of it?
No, the plea bargain applies only to the trial process. And so once the trial is concluded, the plea bargain law doesn't come in again. Now,
who is mandated by this law to enter into the plea bargaining for you? I guess that's something we need to look at.
Yeah,
right?
so every accused person, like she explained, can enter into plea bargaining. That is on the side of the accused. He can act on his own or act by a lawyer if he chooses, except for juveniles where the law mandates that they compulsory have a lawyer. On the other side is the state. Now the state is the Attorney General. And you know that in some of our courts, there are police prosecutors who are not lawyers. Okay. And so the law actually says that everybody, in fact, every prosecutor prosecutes on behalf of the Attorney General. Okay. And so once you enter into a plea bargain, if you are not from the Attorney General's office, you will need to get a copy to the Attorney General's for them to review and be satisfied with it before it's approved. So eventually, the final decision lies with the Attorney General's office. So the fact that plea bargain is an agreement, so the fact that the accused person wants a plea bargain does not necessarily mean that the state is mandated or bound to accept the plea bargain. Right. You have to bring your terms, they bring their terms, and if you agree, then you agree on it. The Attorney General's office gives the final approval if they are okay with it before it's presented to court. And even when it gets to court, the judge has the option to reject it.
I was just about going there. The issue about the judge. How central is the judge to plea bargaining?
All right, so there are two stages where the court becomes involved. Okay. Now, at the beginning, so where parties want to enter into a plea bargain, one party proposes, I want to enter into plea bargain, and the prosecution agrees to, negotiate. Yeah. They are mandated by the law to inform the court. That's the first stage where the court gets involved. They are mandated to inform the court. And then the court grants an adjournment for parties to go. So the trial stands adjourned for parties to go and then do the negotiations. Right. Now, when all of that is concluded and the plea agreement has been signed and filed in court, then the court again becomes involved at that stage for considering the plea agreement. And so like Cletus said, the court can do two things, either accept or reject the plea agreement. Now, in accepting, the court has to consider three things. One of it is, does the facts support the charge? The court would also consider whether the accused person had sound mind at the time of the negotiation, entering it. Right. Yes. And finally, if it was voluntary on the part of the accused person. So if all of these things are present, or the court is satisfied that these factors are present, the court would accept. Now, if the court decides to reject, the court would have to state reasons. Perhaps the court disagrees with the proposed sentence, for example. Looking at the facts, the judge thinks, no, it was too grievous, or there are what we call aggravating circumstances, and so the judge refuses to accept the sentence that has been proposed. The judge has that right to reject it, and then parties go back and renegotiate. So that refusal, that ruling refusing it cannot be appealed against. What you have to do is to renegotiate, because, you know, the whole thing, we're trying to facilitate the process.
So how then do you come out of it? And Cletus, probably you'd want to take care of that for us, in terms of coming out of the whole situation and going back to the trial. Is that possible?
Yes.
For you to say, okay, well, it didn't work on the first attempt, so let's try once more to go the full length, and if indeed I'm complicit, then you can go ahead and try me.
Yes, so you can result from the agreement at any time, right, until the judge has eventually accepted and passed judgment. When the judge accepts the plea agreement and pass sentence, you are closed. Your case is closed there. But until that stage, at any stage, even the day the judge is going to accept it, before he accepts it, you can say that, look, I signed this agreement, but I no longer want to go on. I want to go to full trial. Right. And the judge doesn't have a say there. They just have to allow you to go to the full trial. When the judge also rejects the agreement, you have an option to go back, like she said, to renegotiate, or say, okay, if you don't like this agreement, then let's go to the full trial. And so that option is also there. That either you can do renegotiation, because it's a negotiation, so until you come out with an agreement which is acceptable by the court. At any stage, you can, if the court rejects 10 times, you can go and come back 10 times, which is one option.
Would that affect the quality of your case, for instance, and what's happening before the courts?
No, you see, the law, to avoid prejudice, everything involving the plea negotiations, if you decide to go to the full trial, it cannot be used against you. It is what we call the without prejudice, right, agreement. Okay. And so whatever that you say during the plea agreement, or whatever that document that you sign during the plea agreement, if the agreement fails and you have to go to full trial, all those things cannot come in against you at all. They have to rely on whatever that they had before you do all those things to prosecute. So it won't affect the quality of your case.
Okay, let's talk about the rights of the individual and counsel when it comes to entering the plea bargaining. Who has the utmost power to decide?
Well,
maybe Becca would take that first.
Yeah. All right, so I think Cletus mentioned earlier that if it has to do with a juvenile, then there's that mandatory requirement that there be a counsel. And also the juvenile doesn't get involved alone. So there's a parent or a guardian or whoever is acting as a guardian ad litem.
To be there.
Yes, so the juvenile is never alone. If it has to do with an adult accused person who is an adult too, you can opt to enter into it without counsel. You can also choose to engage the services of counsel. And if you have counsel, the negotiation is between the counsel and prosecution. Of course, the understanding at the bar and even in law that the counsel acts on the instruction of the client. And so there's that presumption that whatever the counsel is doing is on the instruction.
You're doing that together.
Exactly, of the accused person. So there really isn't who has power and who is, I mean...
So it's got to do much more with negotiating your way out.
Exactly, but also still within the limits of the law. Now, you see, offenses, every offense has a punishment for it. So even if you are negotiating, you can't negotiate out of the law. Right. So if the law says, for example, that the minimum sentence for this offense is 2 years, you cannot say, me, I want 1 year. That won't work. Okay, so you have to still negotiate within
the bounds of the law. Yes. Interesting. And we need to go. Let me give the final words to both of you, a minute each. I'll start off with you, Becca.
Okay, so I'd say that this is an innovative legislation, and as LADA Institute, we look forward to this law taking seed in our criminal justice system, because we foresee that the benefit is going to be immense, both to the state and to the accused person. And so we really look forward to having that implementation really grounded in our criminal justice system. And for you, Cletus?
Yeah, so plea bargaining in most of these developed countries is actually one of the ways which they try to, one of the innovative ways they have they've used to shorten trials and to ensure speedy trial of criminal offenses. Because even under the Constitution, your right to fair trial includes trial within a reasonable time. So the law even allows, the Constitution even grants you that right. And so this is one of the ways we can actually use to shorten trials and then free our prisons. So it's a very good law. I'm sure in the coming days, a lot of people will take advantage of it. And then maybe we will all see the benefit of it.
Yeah, and we'll see how it goes. But obviously, we can wish you the best at LADA Institute. Thank you, Rebecca and Cletus, for joining us.